right, then it is 7:02. I see the city manager is here. And Sean, are you joined by Bernie Waugh?
Yes, I am.
Okay, great. All right. Well, then I think we've got everyone. So let's go ahead and call this meeting to order. This is the Fair and Impartial Policing Task Force, also known as the Welcoming Lebanon Ordinance Task Force. And I'm Karen Leo Hill, Chair, and I'm going to turn it over to Sean Mulholland to read us the fine print.
I don't read it. I just take it out of the gray matter. So I'll just do it that way, if you don't mind. This meeting is being conducted in accordance with the provisions of RSA 91A and emergency order number 12 issued by the governor of the state of New Hampshire in regards to the COVID-19 pandemic, which does not make it practical for this task force to meet in person, nor to allow the public to meet with the task force in person due to the risk of spread of the virus. Therefore, it is being conducted virtually, and those who wish to participate by phone can do so. If you wish to participate by phone, please dial *6 and you will be allowed to speak when the chairperson, which is Councilor Hill, recognizes you and allows you to do so. If you have any problems, you can reach me by email, and that's on the website, or Mulholland, if you can spell that, at LebanonNH.gov. But you wouldn't be here if you needed that information anyway.
Yeah. Great, thank you. And so we are being recorded. This meeting is being recorded. You should all know that. And we have been using the chat for people to ask questions and things like that. That's proven, I think, pretty helpful in the past. So if you're a guest with us, you can feel free to use the chat, and we will try and check it pretty regularly during the course of the meeting. I am going to go ahead and call the roll. And Sean, if you don't mind pulling up the agenda so that after I call the roll, then we can share the agenda for tonight on your screen. That would be super.
I will do that.
Thank you. Calling the roll. Let's see. We'll go with Devin Wilkie.
Wilkie is here.
Diane Root.
Root is here.
Casey Montaz.
Casey Montaz is here.
Barry Schuster.
Barry is here.
Sue Prentice.
Sue Prentice is here.
Kathy Beckett.
Kathy Beckett is here.
And Karen Leo Hill is here as well. And so we are all present and accounted for. And I know that we are also joined by the city manager, as well as Bernie Waugh, who has been acting as legal counsel for the city on this matter. Do you want to say hello, Bernie?
I'm here. My voice is a little weak because I went jogging today, but I'm here.
All right, well, bravo. And so we have the agenda here tonight. We are going to have, we have actually just one set of minutes, August 18th, to approve, which we'll do in a minute. And then we're going to go into discussion. We have provision 4, provision 5, section B. We have provision 9, which is implementation and enforcement. We also have, I'm not sure, I'm sorry, provision 8 is also something that we need to be talking about tonight. And then ultimately, we'll discuss the overall draft recommendation to the city council. Our practice has been to take public testimony right around 7:45, the halfway point of our meeting. And so I expect that we'll do that as well. So for those of you joining us for the first time, just understand that we will be turning to the public for public testimony right around 7:45. Although you're welcome to put something into the chat before then if you hear us speaking about something and you'd like to include a comment. And then we'll come back together. Now, originally this was previewed to be our last meeting, but I thought before we dive into the agenda, I think I'd like to just have a quick conversation among the members of the task force to talk about what looks like a pretty heavy load for tonight. And so I think I would like to ask the task force to consider going ahead right now and scheduling another meeting for next week, 1 week for tonight, so that we can still almost satisfy the requirements and of doing our report to the city council at the end of September. and work with the timeline that we're trying to accommodate. So let's see. I see Devin. I see your hand raised. Go ahead.
I have actually 2 other events at this time next week, so I would not be able to make it.
Okay. And so we don't want that to happen. Then do we agree? I guess maybe an initial question would be, does the task force agree that another meeting would be helpful to accomplish our work? I see Casey nodding his head and Barry nodding his head. Diane as well. I know Kathy had emailed me, so I think she was anticipating that as well. Sue, yeah. So then let's just go ahead and without having identified specifically the meeting, I think the best is probably to schedule it by email. And that way, maybe I can send a doodle poll or whatever it's called so that we can compare schedules next week. I know Wednesday we have a city council meeting, but maybe there is Monday, maybe there's, sounds like not Tuesday. How does Monday look for everyone, actually? No, Monday does not look good for Devin. All right, well, we might have to change the timing. If we were to move the meeting up to a different time, would that change things for you, Devin, say on Tuesday?
Let me check. I have, if it's between 5 and 6:30, I'm available.
Okay, so we'll continue organizing this. All right, I see Kathy nodding her head. I see Casey nodding his head. Barry's nodding his head. Diane, can you
Madam Chair?
Yes.
This is Bernie. I'm not available for the first 3 days of next week, but I don't know if you think you still need me, but I thought I'd better say that in advance.
Okay. We will continue this scheduling discussion over email so that we don't eat too much more into our meeting time tonight. We do agree that another meeting would be helpful. We will try and make sure that it happens next week. So we will continue this conversation. Let's see if we can maybe deal with everything we need to deal with Bernie tonight. But no pressure. That's the thing that I really wanted to do, was to take the pressure off of this meeting tonight so that we didn't, that no one felt shortchanged and that we could all participate as fully as we would like to. Thank you. Let us take up the minutes of August 18th. Have people been able to review those? And are there any corrections or changes requested? If not, then if someone could make a motion to accept the minutes. I see Devin raising his hand.
So moved to accept those minutes.
Thank you. I see Sue Prentice with her hand raised. Is that a second?
Yep, correct.
Thank you. And then we'll go ahead and have a roll call vote. Kathy Beckett.
I vote yes.
Karen Leo Hill votes yes. Casey Montas.
Yes.
Sue Prentice.
Yes.
Diane Root.
Yes.
Barry Schuster.
Yes.
Devin Wilkie.
Yes.
Great. I think I just did that in alphabetical order, and I will attempt to do that at the end as well. All right. Now, returning to our agenda, looks like we are going to take up provision 4. Now, this is the new provision 4, I believe. And is it possible for you, Sean, to share that on the screen?
Yes. Hold on 1 second.
I should have given you a heads up. I'm sorry.
Nope, that's okay. You should have it, right?
Yes, we do.
Okay.
All right. The new provision 4, no agent or agency of the city shall disclose information regarding the U.S. citizenship or immigration status of any person unless such disclosure has been authorized in writing by the individual to whom such information pertains, or if such individual is a minor or is otherwise not legally competent by the individual's parent or guardian. We had identified this as a provision that we wanted to bring up. I believe, Diane, that you had sent along some proposed language to add. Diane, would you like to introduce that?
That was not, the language, provision 4 is sort of part of the reference from the original ordinance, that the actual change that I think I was interested in us looking at would be in provision 5, section B.
Oh, okay, sorry, then that will be next. Okay, so then let's go back up to provision 4. Provision 5B is going to be our next agenda item. So on provision 4, then, this was something that we identified wanting to discuss further. Is there anyone in the task force who would like to talk about this provision? This is the language that we've discussed, and it's in our working draft at this point. And so I'd like to open it up. And since I can't see everyone, just go ahead and, identify yourself and offer your comment. And task force, we'll start with the task force.
This is Kathy. So the concern is how 5B basically interacts with provision 4. Because the original provision, and I sent a document with the, I don't think, this doesn't look like the document I sent. So the document I sent had the original provision 3, and the original provision 3 includes the sentence, "This section shall not apply." And we should probably put that document up. It was shared by Beth.
Is that later on in the agenda? Yeah. Thank you, Sean.
This is what you're talking about, Kathy, right here, this provision 3 right here? Do I get the right thing? This is the existing one.
I'm not seeing it.
Hi, this is Devin.
There was a separate document.
Here.
Oh, hold on a second.
People talking. Yeah.
Right
I got it.
All right. I hear Devin, go
There you
ahead.
go. Yeah, that's it.
Okay, and Devin, did you want to say something?
Just helping to find that.
Okay, great. Thank you. All right, so we've got it here. Go ahead, Kathy.
So this is all pretty much connected. The looking at the original provision 3, which you can see includes, "This section shall not apply when such information sharing is necessary to an ongoing investigation of a felony for which there is probable cause, and the investigation is unrelated to the enforcement of federal civil immigration law." Now, when so this became provision 4 in the proposed revision.
All right.
I'm having.
So really we need to talk about 4 and 5B are together. Is that?
Yeah, that's correct.
Okay. All right. So then Diane, I'm sorry I cut you off earlier.
Oh, that's okay. So that, just to go down a little on this.
Yeah. Sean, do you mind scrolling down? All right. Great.
So there was a change in that the exception in 5B, which relates to, it also involves collection, retention, utilization, or disclosure. So disclosure is the key of specific information is required, or so where collected, this is the exception, procedurally necessary as part of an ongoing investigation of a violation of law, including but not limited to a violation of this ordinance itself, or as part of litigation or quasi-judicial administrative proceeding unrelated to the enforcement of federal immigration law or by statute or court order. So the change that's significant is that a violation of law would allow disclosure of information around immigration and citizenship and immigration status. Whereas in the original ordinance, it was not a violation, but it would not apply when the information sharing is necessary to an ongoing investigation of a felony for which there is problem and so forth. So the original provision 3 was taken from the Welcoming Hartford Ordinance. And the Welcoming Hartford Ordinance was changed slightly, and the language was, I'm having trouble moving my document down.
Sean, can you just turn the scroll down a little bit more, please?
Yep.
So the way Hartford tackled the, rather than process, they use unless required to do so by statute or court order. So that made it clearer, or gave it a better, I guess, was more specific around what would be entailed. So sorry about that garbly language there. But anyway, so we're really concerned that the change in provision 4 reflected in 5B will allow someone, for example, who is stopped for a traffic violation to be to have their information, their immigration and citizenship status disclosed. So we're suggesting, if you scroll down to the next page, a revision of that 5B exception. So it would be changed to, and I know that one concern that Bernie had was to ensure that violation of the ordinance was so I'm sorry. So violation of the ordinance was a concern, to make sure that that immigration and citizenship status was not disclosed. So, but we have revised this to where collection, retention, utilization, or disclosure of the specific information is required by statute or court order, or when information sharing is necessary to an ongoing investigation of a violation of this ordinance or a felony for which there is probable cause and the investigation is unrelated to the enforcement of federal civil immigration law. So this revision of provision 5B includes the required by statute or court order language, and includes the concern around violation of the ordinance, and includes the original provision around when there's a felony with probable cause and so forth. So, I mean, that's our suggestion around, and Kara has looked at this. That's our suggestion to replace the original 5B.
Okay.
So,
And so Diane, is this 5B here that we're seeing on the screen as Kathy proposed, this is consistent with what you proposed earlier today as well?
Yeah, well, yeah. I mean, Kathy had really done a lot of the work on this, and she, in consultation with Kira, and just kind of reached out to double check with a few others on that, or get input. Yeah, it is. It's the same one. It's
Great. Okay, just wanted to make sure. All
Yep.
right. So, members of the task force, I just want to check with Bernie Waugh. So, Bernie, the and just a reminder for everyone that our mission, we were tasked with keeping the language and the intent as closely as possible to the language that was passed by the voters of the Welcoming Lebanon Ordinance back in March. And so we are trying to keep as true and consistent to the original language as possible, while clarifying issues that were ambiguous and trying to resolve legal issues that had been raised by the city attorney. And so I want to ask Bernie if there are concerns with this language that we're looking at here on the screen, which more closely matches the language that was approved by the voters. Bernie, any thoughts on this?
Yeah. With all due respect, I simply disagree with it. That was one of the issues that I raised really early on, was this distinction that this makes between a felony and other types of a criminal investigation. I don't understand the logic of it. There's no reason. There's no example that you can think of an investigation of a felony where a disclosure might be procedurally necessary or legally required. That wouldn't where you couldn't also think of a misdemeanor within the same circumstances. And in fact, I think the perhaps most important thing is, when you're doing an investigation, you don't know what you're going to charge, what kind of crime you're going to charge. You don't know what you're going to find probable cause for. So the distinction between, I'm sorry, Diane, I didn't mean to pull a fast one, but when I was drafting the one, it was intentional in my part to take that out. I guess my suggestion would be, to strengthen the notion of required or procedurally necessary as much as you want to. I don't understand the cutoff between a misdemeanor and a felony and how it relates to this ordinance.
Okay, I have to admit, I did not understand why felonies were called out originally either, but let's go ahead and open it up to members of the task force. So if what would happen, I guess I'll ask Kathy and Diane, what would happen if we simply removed the language referring to felony? Or if we used, should we just say, like Bernie was saying, procedurally necessary for an investigation? Is there, I'm just wondering, is there a solution? So I see Devin, I see that you have your hand raised. Let's go to Devin, and then we'll go to other members of the task force. Devin.
Thanks. I just wanted to point out, I may have missed something in these revisions. I didn't see anything comparing or contrasting a felony to a misdemeanor. What I was concerned about, and I also talked with Kathy about this, was that the latest version of 5B that I saw mentioned it was a violation of law, which to my understanding could include any range of possibilities, including the very reasons why federal immigration authorities would show up. I mean, presumably the checkpoints that they have and the other searches of people living in the United States are an ongoing investigation into the potential violation of law that they'll use to detain and that they'll use against people with undocumented status. So I think my big concern is not that we're excluding misdemeanors from felonies, but rather that it sounds like if all we're talking about is a violation of law, I fail to see how that necessarily excludes any enforcement of federal immigration law, of which a violation, I assume, would be some sort of violation.
Okay, other task force members? Or Bernie, was that you?
Yeah, I was about to break in. I think that is an issue and it can be fixed. I was just playing around here with the B as not in Kathy and Kathy's draft, but B in the draft that we got from Barry. And if you were to say where collection, retention, utilization, or disclosure of the specific information is legally required or procedurally essential as part of an ongoing investigation of a violation of law unrelated to immigration or citizenship status, something like that. I think that would help take care of what Devin's concern is. It wouldn't take care of the felony issue, but anyway.
Okay, so Bernie, do I understand that you're saying if we put in after looking at 5B, the one that's on the page right now, which is in our working draft, that's after violation of law, if we put comma, but not a violation of immigration law or investigation of citizenship, is that where would the language go?
I would not put a comma there. It would say violation of law unrelated to immigration or citizenship status, or something like that.
Okay. Unrelated to immigration law or citizenship status. No comma.
And then a comma.
And then a comma. Okay, we have to be attentive to our commas. Okay, well, I guess, Devin, what do you think of that as a possible solution?
Honestly, this is a very long and multi-partite sentence that I would need to see and probably discuss with a few people before I have a strong opinion. I think my first concern is that it sounds like what we're doing is trying to take the narrowest exclusion of this ability to disclose information rather than what my interpretation of the intention had been to take the narrowest definition of where information needed to be disclosed. And I think the concern that I'm seeing is that right now we're tending toward finding only those instances where it is not. I'm sorry, I'm maybe not speaking very clearly. I'm sorry, I had an injury earlier, so I'm trying to focus. It sounds like when we're creating an exception to these provisions, that exception should be narrow and clearly defined rather than being any violation of law that's not limited to immigration status, especially since we've had such long conversations about language as simple as on the basis of or because of. It sounds like anything that we do to such a complicated sentence is going to be more of a barrier to enforcement than it is going to be a barrier to the abuse of vulnerable populations.
And also, Phil, they have these things, little things on
For
the walls.
task force members.
So I was
Barry.
looking around for some fun, and then I found.
Barry, go ahead.
Okay. In the original language, there are sort of two parts that refer to the investigation of a felony, and the investigation is unrelated to the enforcement of federal civil immigration law. And there were sort of two requirements, felony and unrelated, but I don't know if you need two requirements. To me, I think the point is that it's unrelated to immigration law. So I think what Bernie's suggesting, unrelated to law or citizenship status, is good. And I think a lot of the rest of that may not be necessary, because as long as if you're whatever you're collecting, if it does not arise because of immigration law or citizenship status, does it matter if it's a violation of the ordinance or a felony or anything else? The whole idea is to avoid the citizenship inquiries, and that should just apply whatever it is, whether it's a misdemeanor or a felony. And I don't know if I'm missing something, but I think you could just have that single prohibition there. Just a thought.
So how would that, what would that look like, I guess? Or would you be suggesting that we just go back to the, original number 3?
No, I think it might shorten it, and it removes the concept of felony, which I'm not sure if I agree with Bernie, but I don't know if you even need to get to that point. But where collection, retention, disclosure of specific information is required, that as part of an ongoing investigation of a violation of law, there's the ambiguity, misdemeanor, felony, whatever, but it's any violation of law. But so long as it's or unrelated to immigration law or citizenship status. So if there is some investigation, if it's related to immigrant status, then you can't collect it or retain it. But if you're doing a traffic stop or a robbery and it comes up, I guess then it's reportable. But the whole idea is that you shouldn't be disclosing and retaining the immigrant status and immigration law issues. And I think it could almost stop there, period.
Okay.
Right after unrelated to immigrant law and citizenship status. Yeah.
Yeah, I guess what I'm struggling with here is that we heard testimony from the police chief who told us that they literally do not ask about immigration status, and they literally do not document, they do not collect information about immigration status or even documentation status. And so I guess I'm a little perplexed.
So this is Kathy. The purpose of this ordinance on the whole is to ensure that someone, whether no matter what their citizenship or immigration status is treated like any other person. So immigration status should never be an issue for our local police department. Now, unfortunately, there are other ways to gain information about immigration status other than asking. So, for example, when someone is stopped and they have if you look at the current fair and impartial policing policy for Lebanon, they should be able to provide various documentation, and it doesn't necessarily have to be current. So a visa, a passport. So there, as I said, there are other ways to discover someone's immigration status. And that information, it has been used in the past and resulted in someone being deported. So we don't want that to happen. And my feeling is that we don't want someone stopped for a traffic violation and ending up being deported because their immigration status has been disclosed. And in certain, you know, in some felony, some situations where it might be considered a felony, that is also, could also be a situation where we don't want immigration status disclosed. Because, as I said, for fair and impartial policing policy, we want every person, regardless of citizenship or immigration status, to be treated in the same manner as a citizen. So that's what this is all about. In addition to people of color, and often immigrants are profiled and targeted because of their color, their religion, their language. And so, you know, if we're really looking at the intent of the ordinance, we want to protect people who are, regardless of citizenship and immigration status. That's you know, so.
Okay, and I agree. We have agreed numerous times over the course of the summer that the intention, that there is broad consensus on the task force that this ordinance is about preventing and prohibiting discrimination on any number of categories, but specifically immigration status, citizenship status, and a number of other categories that we've talked about. So I don't think there's any disagreement there. We all agree, but we've also had testimony over the summer or over the last few months, and I thought that we had come to some consensus after we had spoken with the police chief, who explained that immigration status is not collected in the city of Lebanon, that is not collected. And so I thought that we had consensus, and now I'm a little perplexed that it seems that now we don't have consensus. So I'm just going to open it up to the task force to continue the conversation, because clearly we need a little more conversation on this.
Madam Chair?
Yeah.
This is Bernie. Could I just respond to a couple of things? First of all, in response to Barry's suggestion, don't forget the part of that says or by statute or court order. I want to assure the members of the task force that it certainly is not my intention that somebody stopped for a traffic violation or anything like that is going to be deported, or that constitutes an excuse for, and that's why it says is required or procedurally necessary. And I would imagine, and you know, you can pick other words there, but my imagine is that would be extremely narrow. I'm trying to think of an example, but one might be, let's suppose that you're investigating a potential hate crime, and part of the element of the crime is the status of the person who was assaulted. You'd need to bring that out in the evidence and as part of the investigation. You know, that kind of very narrow situation is really what this is all about. This exception.
Okay, and I see we have a comment from Susan in the chat who said, I feel we need the ordinance, whether or not the chief says that, the chief can at this point change his mind at any time. So I absolutely, and we did discuss this, that an ordinance has a different kind of a weight, obviously, than an internal administrative policy. And so that is why we're here, and I agree. But what we have done is, my understanding is that we have created a prohibition on collecting certain kinds of information. And now in provision 5B, provision 5 is now where we are putting in an exception. And so the type of exception is what we're talking about. There is a broad prohibition. So to be clear, this ordinance is memorializing in law what our internal police policy is, which is prohibiting collection of data about immigration status, citizenship, and a host of other issues. But it is carving out a very specific exception. And so that's what we're talking about. Who else? So I think we're having a little discussion. I'm not sure why. I'm not. All right. I guess we need to just keep talking. Someone else needs to talk.
Casey
Casey.
here, if I may. Yeah. So I see what the concern is when you say a violation of law, because if the exception is the investigation of a violation of law, anything is a violation of law, and therefore it sort of then defeats the purpose of the other four specific prohibitions. So I think by saying a felony, what it is saying that it cannot just be any violation of law. It cannot be jaywalking, or it cannot be speeding. It has to be something serious at the level of a felon. I think that's what is being said of over here, and that's why it is. Otherwise, then this will be a loophole by which, by any violation of law, then this information could be then gathered and shared. And I think this is what we're trying to avoid.
So Casey, you think that it's reasonable to have a distinction of a felony as being a higher threshold?
Yes, I think that is the intent. Yeah.
Okay. Who else? Okay, so if the proposed language,
Karen Barry here.
Barry,
I'm on the phone.
Oh, okay. So, all right, yeah, and I think Sue Prentice also was having a challenge with her internet, so.
I got back in.
And she's back in, great. Barry, you're here on the phone. Go ahead, please.
No, I just wanted to let you know that I am on the phone.
Okay. All right, so if we go to the language that was proposed by Kathy Beckett. Bernie, I know that you had reasons why you thought that this should be modified. You've heard the discussion. Do you have concerns about this language that's being proposed? Do you continue to have concerns about this language being proposed? Casey raised the idea of why felony is being singled out. We've added in the idea of the violation of this, investigating a violation of this ordinance, which was something that you had proposed. I guess, can we live with this, this proposal?
I still don't support the notion that you're only enabled for an investigation of a felony. Again, how do you know how do you know if it's going to be a felony when you start your investigation? And what about, I was just talking to the manager when I first came in. What about a situation where you charge somebody with a felony, but then there's a plea bargain and they plead guilty to a lesser included offense, which is a misdemeanor? Does the investigation suddenly then become illegal? I don't know how you, at what point you determine that there's a felony involved.
I may address that.
Yeah, Casey, go ahead.
Yeah, I mean, if there is a burglary, I come into my house and somebody broke in my house and stole my snowblower, that's a felony. That's already granted. It's not like every time that you engage in an investigation, you don't know where you are going. That's when you go fishing. Usually when you are investigating something, you probably have a crime that has already been reported and you're following up to establish who did it, but you already know what the crime was. So that doesn't apply in every single case. On the contrary, you already know what you are investigating. You already have a crime reported, so you already know what you're sort of looking at to begin with. Doesn't happen the other way around. Sometimes that will happen, that in the course of investigating something, you learn something new, but you always have a premise to begin with.
It's true that there's something that generates an investigation, but it certainly is also true that, that until someone is actually charged, you don't know. And there are some, this is a fine line between misdemeanor and felony. I mean, people are innocent until proven guilty, and investigations begin sometimes without knowing exactly what the charge is going to be that's brought. I mean, I'm thinking of you can think of any number of examples where a prosecutor might not bring, might bring a different number of potential charges. I think that is a real problem. All right, Devin, I see your hand up.
Yeah, I had two thoughts as this conversation is going back and forth on an actual, charge. I guess I'm not sure where the confusion is here, because to me it doesn't sound like this exception only applies to a finished, charged, fully executed felony conviction. It sounds like this is an investigation. It applies to an investigation of an offense which is considered a felony. It doesn't matter if the charge is then reduced to a misdemeanor. It's, the investigation is for a crime which is considered a felony. I don't think, investigating a burglary becomes something other than investigating a burglary just because a burglary didn't happen. It was still an investigation into a burglary. But also, and in addition to that, I'm curious why we want to leave the door open. I guess this comes back to my previous concern, that it sounds like what we're doing is leaving the door open for collection, retention, utilization, or disclosure, which of course specifically applies to immigration status in the 3rd and 4th provisions. Why we're leaving the door open to collecting and disclosing this information when we don't know it's necessary, rather than accepting that what we're doing specifically is restricting this collection, retention, utilization, or disclosure when we don't know that it's necessary. You know, you say you don't know a crime has been committed. If you don't know a crime has been committed, in what instance do you need to know somebody's actual immigration status? You know, whether or not you question somebody's, I believe somebody had mentioned in the chat, somebody's perception of a person's immigration status, that's not relevant to their actual immigration status. And so I think that's where my concern, that was Susan who said that, thank you, Susan. My concern is why we're saying, you know, make sure we can collect, retain, utilize, disclose this information in any possible case, when the entire intent of the ordinance that, as both Karen and Bernie pointed out, we're trying to preserve and enhance, is to avoid doing just that. So I think those are my two concerns.
Okay, thank you, Devin. And you know, our task is to remain as close as possible to preserve, or as much as possible, while addressing the legal concerns that have been raised. And Bernie has raised this concern. And so that is why we're doing this. And Susan asked for an example. There are numerous, within the child abuse statutes, there are numerous child abuse crimes that are considered misdemeanors, and there are numerous child abuse crimes that are considered felonies. And so, and that would be true in a number of different areas. So, you know, there are numerous examples, and we don't need to cite all of them, but, you know, when you're investigating a family matter, like domestic violence, or you might not know what you're getting into when you begin that investigation, and it might result in a felony, and it might result in a misdemeanor. And so I can understand why there is some concern about leaving the language in there about felony. This is not, we're not talking about conviction. We're talking about investigation. And when you investigate, you don't know before you're getting into it. So let us continue discussing. I see, you know what, I think I'd like to go ahead to the public. I see that Phil and Judy Bush have said, I agree with Devin's thoughts here regarding investigation of what is thought to be a felony by the investigating authority. It seems reasonable to limit the exceptions to such investigations and those related to this ordinance. Okay, so supporting the idea of leaving in the language about felony. Devin says, could I ask for an example that specifically applies here, that information about immigration status is necessary? I see Barry, I just let Barry back in. All right, so is there anyone in the public who would like to weigh in? Is there anyone, any member of the public who is here either? Yeah, I see Sarah Raitt has her hand up. Sarah Raitt, go ahead.
Hello, everyone. Can you hear me all right?
Yeah.
Yes, we can hear you.
I really wanted to thank the task force for bringing forward this issue because I think it is very important. And I'm very seriously concerned that the language that was proposed before this meeting is sort of degrading the original intent of the people as they voted for the ordinance. But also, I'm wondering, as I'm looking at the language, and forgive me because I'm not a lawyer and I don't have any expertise in this area, but I'm looking and I'm wondering whether if there is a felony, is it understood? Is it necessarily the case that there would be a statute or a court order in which there is a requirement to collect citizenship status information? I'm just wondering whether, because if we have this clause in there already that says we can collect information, retain information, distribute information when it's required by statute or court order, is it really necessary to say if it's not related to, forgive me, I'm losing my words here, but I'm just wondering whether, if we're already saying that, okay, in such cases in which it's collected by order of statute or the court, it seems like perhaps maybe we don't need to say that there are also cases in which information sharing is necessary due to an ongoing investigation of a crime or a violation of law, because it seems to me that if we just struck that second clause entirely, we just had information that's required by statute or court order, and then also cases in which the investigation is unrelated to the enforcement of federal civil immigration law, and we have that be an and between the two clauses, would that perhaps resolve this issue? Because why would we need to say, for example, there was a traffic stop and somebody was stopped for a minor infraction, that it seems totally unconscionable and immoral that somebody's citizenship status should come up as part of that stop and as part of the investigation of what actually happened, or if there was an accident or something of that nature. And so I'm just wondering if it would be sufficient to say in those cases in which it's required by statute or court order, because if a crime has gotten to the point where there is an actual court order to investigate further and gather that information, would that not be sufficient for the purposes of the investigation? I'm sorry, it took me a long time to get there. Hopefully that makes sense.
That's fine. Thank you so much, Sarah. I think now I saw Susan writes a note here in the chat. I think that's what Barry Schuster was saying. Diane said, I think Bernie suggested we might be able to tighten this up with language about legally required, procedurally necessary, and immediately relevant, or some such, to narrow the exception this way. Okay, so those are some thoughts. I guess we'll take some more public testimony and then see if we can resolve this. All right. Is there anyone else in the public who would like to comment? Okay, if there's no one in the public, then why don't we go to the task force? Sue, did I see your hand being raised?
I just want to go back up to just provision 5 and go through A and then go through B. I feel like I'm like upside down, you know, in one of those airplanes, and you got to come right side up again. And okay, when the collection, you guys can keep. I'm just.
All right. Well, I think that we've come to the end
Can
of
we
our
scroll up just a little bit while I'm
kind of
go.
fruitful
Thank you.
discussion. Yeah. I think we're trying to do some wordsmithing here as a committee, which is a little difficult. So I think I'm going to, I guess, ask someone to continue working on this and to come back with some, could I ask Barry and Kathy to work on this together?
Sure.
I know Barry is on the phone, so hopefully he is also amenable.
Yes, Karen, that's fine.
Great, thank you. Devin says he'd love to hear Bernie's response to Sarah's point that we removed language from or when information to or a felony in order to solve this dispute. Bernie, any thoughts on that? I know
Said.
to put you on the spot.
Scroll up.
Karen, I'm sorry, I did not write down what she said, so I'm not sure how I can respond.
I think her point was to remove the language from yeah, right, from
Right here.
on provision B, remove the language from oh, I think it's on a different version of that one.
That was my problem.
Yeah.
I wasn't clear what version she was talking about.
Okay, Sarah, are you still here?
Yes, hello everyone. Sorry about that.
Yeah, no, that's fine. Sarah, are you able to restate what you said?
Sure.
If possible?
Sure. Okay, so I think perhaps I was working off of the proposed language that was shared with the task force this evening. And so the wording was a little different. Yeah, I think it was sort of switched around. But the salient point that I was trying to make, very poorly, I apologize. It's been a long day. Is that what if we just required? What if we just made exceptions for the following cases? When it's required by statute or court order, and the investigation is unrelated to the enforcement of federal civil immigration law.
Mhm.
Is that clear, what I was trying to say?
That's much clearer.
Sorry about that.
No, it's okay, Sarah. I'm looking to cut to the chase. I get it now.
Bernie, I think she's looking for your response on that.
Oh, yeah. So you're not going to say anything about investigations at all? I guess I'm
I think let's see if Sarah, what I'd like to do is invite Sarah, if you would be willing to write your thoughts down and email them to the city manager, that would be great. And then we can incorporate that into the discussion. So what I'm doing is asking Barry Schuster and Kathy Beckett to continue working on this so that in anticipation of a meeting next week, we can see if this is something that can be resolved. And I think it's going to be better resolved in a smaller discussion than at the group level. Okay. I think because I do want to at least talk about, I think the next one on the list was enforcement. Is that something that we can move on to discuss now?
Yes.
Okay. And so Kathy, this was something that you had worked on, and we had some discussion at the last meeting, or I guess it was 2 meetings ago with Bernie. So Kathy, why don't I ask, should I have you introduce this, or well, I'll ask Kathy and then Bernie to talk about this.
Well, I think it'd be more appropriate if Bernie introduced this. This is a change from what we had come up with at the last task force meeting. So
Great.
Bernie has condensed it. So.
Thank you. Go ahead, please, Bernie.
Sure. The version that's in italics on the working draft was something I put together with Kathy for about a month ago, but it hadn't been discussed with the manager. And then 2 weeks ago, we got copies of existing personnel policies, investigation policy, et cetera. And so the second the other draft that was dated 9/20/28, released to the public, was my attempt to go back to a more streamlined version, if you will, and to leave out things that were already covered by personnel policies for those violations involving a person who is an employee. The second one is quite a bit shorter. I'm not necessarily saying that everything in the original one is legally required to be taken out by any means. There are some things that could be put back in. I think I was aiming at making as few changes as possible. The version that was released yesterday has 4 paragraphs. A would be similar to what's in the voter passed ordinance. The only change there is that the word offense has been relocated. B would be a provision that applies to that allows complaints to be filed when the person believed to be violating the ordinance is a city employee. And the original version, the version from a month ago that I worked on with Kathy, had a requirement that the city should develop a complaint form. I left that out of this. It could be put back in, but the existing personnel policies are so wide open in terms of allowing what type of complaint you need that I've come to believe that a complaint form would be counterproductive in the sense that it might, that certain employees might think that there had been no complaint unless the form was filled out, which is contrary to the way the personnel policies work. So the first half of that just talks about the ability of a person who believes that a violation has occurred to file a complaint in whatever manner they want to. Basically, they can submit it anonymously even. The second part of that paragraph B allows the manager, as he has discretion to do in the case of other violations of the criminal code by an employee, to the discretion of the manager to delay any internal investigation pending a referral of the violation to a law enforcement agency having jurisdiction. That language comes from a section of the investigations and complaints procedure that already exists and that the manager has adopted. But it wasn't clear to me, the reason I put it in here was that it wasn't clear to me that actually applied to violations complaints. The paragraph C applies when the person being complained about is not an employee. For example, an appointed or elected official. And again, it sort of leaves it up to the city manager what action to take, including the possibility of referring it to a law enforcement agency or referring it to the council for such action as the council deems justified. Every case I think is going to be different. So it intentionally does allow some discretion. Remember though that this is still a violation, so that the law allows a violations complaint to be filed directly in court without going through the city complaint procedure at all. My belief as attorney for the city is that it is preferable for the person who thinks there's a violation to file a complaint with the city and that it can be taken care of that way. But they also have the option of doing something else. Paragraph D in the slimmed down version is simply a statement of non-intent to create a civil cause of action. My original version of that paragraph talked about nothing is deemed to restrict any person from pursuing other alternative remedies. But I decided that was unnecessary. Nothing in this ordinance could possibly interfere with a person's ability to seek alternative remedies. And so I didn't think it was legally necessary. It would still be the case. So that's where that came from. I guess I want to emphasize that my role again is as a legal advisor. I'm not supposed to take a position on policy issues, and there are some things in the longer version that could, as a matter of policy, be put in and added to the shorter version, such as the development of complaint form. That really is a policy issue up to the task force and ultimately to the council.
Thank you, Bernie. Who was that? Go ahead.
No, it's just me. So wouldn't a complaint form, so if it's in the ordinance and it said that there'll be a process, then it would be, it's like writing an administrative rule, Bernie, and then a policy is developed from that rule that, has the form. Do we have to, I guess I just think it needs to be stated, here's the process here, and, a complaint form will be, I don't even know if we say a complaint form needs to be developed, but I don't think we have to do it here. I don't know.
Well, that's part of the issue, I think, when the manager passed out the policies. And remember, this is an ordinance that is under the authority of the council, whereas these personnel policies are under the authority of the manager. And so, in a way, a part of the motivation for making this shorten and slim down was to leave it up to this manager or another manager to make the more specific policies. So,
agreed. As a council, we will develop a policy. We will vote on a direction, and then the city staff, and in this case, we're talking HR, the city manager. I know that discussion, and they will, put together the tools in order to execute that on our behalf. It's very much in the weeds. Okay.
I again apologize for my voice.
It's okay.
No, your voice is fine. All right. Any further discussion on this? This was something that was not in the ordinance originally, and was something that this implementation and enforcement provision was something that we have developed that because it was one of the deficiencies in the ordinance that the city attorney had identified. And so, so we have a proposal before us. So task force members, any further discussion on this? I see. All right. I see comments in the chat. Phil and Judy Bush have said, if we are seeing the full provision, I'm not sure I see the implementation section. I expected some positive statements of how this ordinance will be assertively implemented. Phil.
Well, Phil, tell me what you mean by assertively implemented. I just want to be clear.
Well,
I hear your voice. Great.
I don't have specific ideas. I was looking forward to seeing some of it. It seems like any ordinance, maybe needs a process for how city staff will implement the ordinance. I don't have. It's just seeing implementation and I don't see the heading. What is it? Implementation and enforcement or something?
Yep.
Yeah, I just don't see anything about implementation, I guess. It's all about, complaints and violations.
I'm not sure that we normally have implementation. That doesn't seem like something that we normally have in our ordinances. Normally the ordinance includes an enforcement mechanism, but there's nothing in the parking ordinance, for example, that says the parking, the police department will send out someone to check the meters every 4 hours, for example. So we don't really have those in other parts of that's the implementation really happens at the policy level. I think, what we've heard from the police chief is that he collects data and routinely analyzes that data to see if he finds any evidence of biased policing, and that he also is able to use the data that's collected. So he routinely does that in a proactive manner. And then if a complaint was raised against a particular officer, that he has the data to then be able to analyze with regard to that specific officer and investigating that complaint. So we do have those examples as well. Let's see, Kira Kelly, I see you said, can I raise an easily resolved concern with proposed provision 9? Please go ahead and do so.
Sure. Sorry for being late. I had another meeting, but I just wanted to raise a concern related to taking out the phrase about this not precluding other causes of action, and the need to be specific about that, because there is a kind of general rule in law where if you file a lawsuit or if you sue in court, the court will require you to have exhausted all of your non-judicial means of recourse before going to court. So exhausting any agency or administrative recourse. So if we have an implementation and enforcement provision in an ordinance that says, if you suspect that you've been subjected to a violation of this ordinance, then you should do X, Y, and Z. That in a way actually does preclude going to the court, because the court will say, well, you didn't do X, Y, Z, so you can't go to court yet. So it does leave, and I hear Bernie's interpretation, and I think, that because we have two different interpretations of this, some clarity might just be a really good resolution to it. So kind of clarifying the fact that there is alternate remedies. This is one. The courts remain another remedy, rather than having people be confused as to whether they had to do this in order to get to the courts, and rather than having the courts be confused as to whether or not this ordinance was trying to impose an administrative remedy that people must complete first before going to the courts.
And so which section is that in? That's in 9 B?
It could be in 9B, or it could be in 9D. This ordinance shall not be construed to create any civil cause of action, nor does it preclude, but does not, I don't know. Yeah, Bernie, you had some language, I think, that you had in originally and took out.
It's I think what you're looking for is in G of the part of the longer version in italics. Again, this is I think I do disagree with her. I don't think that an ordinance is going to create I don't think a local ordinance can create a requirement to exhaust administrative remedies, but it's a policy decision whether to put that in there. It's not gonna be illegal to put it in there.
Okay.
I think, right, I definitely think that, right, Bernie and I should
Would
not
add that back in.
decision, but maybe the task force should decide, do you want to be explicit about there being alternate remedies through the court system, or do you want to, try to, like, because, I mean, if you think about, like, it's the same with planning boards, like, you can't appeal planning board decisions to the judicial system until you've exhausted the
Correct.
local zoning board procedures. And so those are local ordinances which create an administrative remedy that you must exhaust before you go to the court system. So we do have a little ambiguity here, and it's not our role to make a policy decision for you all, but if you want to resolve that ambiguity, you could take former version provision 9G and add that here to be explicit that this is not meant to be a pre-barrier to seeking a judicial remedy. It is merely an alternate remedy.
Okay, that's helpful. Thank you. Okay, thank you, Kira, for that. And Diane commented, I'm also wondering if there would be benefit to collecting data on the number of complaints and their resolutions, somewhat like the PD has, both relate to fulfillment of non-discrimination commitments. So Diane, are you suggesting that maybe we would want to have some sort of an additional provision or something in this, I guess, in another section in section 9 that would address having a process where complaints are collected and reviewed on some regular basis?
Yeah, I guess I was wondering about the will of the task force on that. It seemed to me that, that this would create some parallel between the law enforcement side of our city entity and the civilian side, if you will, that there would be some parallel between them about data collection and accountability.
So this is Kathy. First I'd like to respond to Kara's suggestion, and I think it would be good to have that language included, because I feel that it makes it, if we do not have that language included, it will discourage some people from pursuing a remedy that, through the courts. And also, I do agree with you, Diane. I think it's a great idea to keep track of complaints and review them, and in order to, to make sure that the ordinance is being properly followed.
Yeah.
All right. Would there be any, I guess, is there any objection on the task force to this concept and to incorporating that language? So the idea is that we just want to make it explicit that anyone who feels that they have been
wronged,
that they've been wronged, can pursue the administrative remedy that we've laid out here, but that they can also go to court directly, and they don't have to exhaust the administrative remedy before going to court. Is that something that we all agree on? Sue, I see your hand.
But didn't I hear, Kira, Kelly, correct me if I'm wrong, didn't I hear you say that the court would turn around?
Sue, go ahead, and then anyone.
Can you hear me?
Yep.
So isn't it that you have to exhaust the administrative procedure before it goes to court?
Only if you don't, if the rule doesn't say you can go to court directly. Normally you have to. So the default position for the court is that they're going to say,
what are you
at
doing?
least that's what I understood you to be saying. They're going to say, have you exhausted all your administrative remedies? And then if you say, you can say no, and they're going to say, okay, we'll come back after you've exhausted your administrative remedies. Or you can say, no, but I didn't have to because the ordinance says I can come directly to court if I want.
Madam Chair, could I just comment there?
Yeah, sure, Bernie.
I think the distinction here is, and I think Attorney Kelly used the analogy of going to a zoning, going to court to challenge a zoning decision without doing an administrative remedies. But the difference there is that the state law requires you to exhaust your administrative remedies. Here, we're talking about an administrative remedy created by a local ordinance. I just don't think that a court is going to do that, is going to require you to go through the complaint locally. You know, again, that was certainly not my intent. I don't think it can be done locally to make that a requirement. I think that if it's going to be a violation offense, it's something that somebody can go to court on.
But Bernie, I think I also heard you say that you have no concerns if we put that language in there, that you don't see it creating a legal problem.
I don't.
Okay, so then task force members, this is a question, this is a discretionary question for us. And Kira is suggesting, she says, she has some proposed language. This section is not meant to be an administrative remedy as a required prerequisite to judicial relief. Okay, so that's something that we can consider for next time. Well, I'm glad that we agreed we're going to have a meeting because clearly we need it. I see we're coming to the end of our time here. I think, Sean, if you could stop sharing the screen for now.
So
don't hang up, just stop the screen.
So
okay, I'm still here.
Okay. Yeah. All right, Stu, go ahead.
I just want to get back to implementation and enforcement difference. So implementation is, we're saying, okay, here's the ordinance. Okay, it's being implemented as of this date, and this is how it will be enforced. So if there's a violation of it, it's not necessarily, it says.
Uh-oh, she's frozen.
Oh no, Sue, you're frozen. Casey tried. Okay. Anyone have a magic wand?
I don't know where I placed mine. I'm looking around. I can't find it. Magic, that is.
Okay. All right. Well, okay. Well, anyone other than Sue with thoughts on moving forward? So we still have to address what we have to resolve what we were talking about earlier. We have to resolve this question, though it sounds like this one, at least on this question, we don't have a like a discrepancy between, we're not dealing with a discrepancy with legal counsel. So on this one, this is strictly a discretionary decision of counsel of the task force. So at least it's not under the, under those conditions. We still have, the big one that we still have ahead of us too, that I see is this question of the notification provision. And what we started talking about at the last meeting, which was the concern that employees or other agents of the city could be personally liable for interference. And so that is that's a substantial issue that we still have to address. I see a question from Susan. Is the current provisional draft that task members have created available to the general public? Yes, Susan, that is part of the agenda packet, the agenda documents that are on the city website. They were emailed out to us, to the task force members earlier today, and I believe that Beth has updated them on the city website as well.
Madam Chair?
Yes.
The one other issue that I think is still on the table is is what's in red ink on the 4th page, which is a part of new provision 7, formerly 5, and the question of whether, you know, the intent of the section is prohibits participation in an interagency database such as National Crime Information Center. I think that should be resolved.
Okay, yes. Yes, so we definitely still have a full meeting ahead of us. Is there, I guess, and is Sue Prentice back with us?
Yes, I'm here by phone.
Okay, all right, Sue is with us by phone. Okay, so I guess I'd like to ask if there's anyone. So we've got Kathy and Barry who are going to work on the 5B section. I don't think that we necessarily need to assign anyone to this enforcement section, unless, I guess, let me ask the task force before I move on from enforcement. Are there other issues? Do we have other issues with the enforcement section as proposed by Bernie Waugh that he just reviewed with us? Kathy, I know this was something you were working on. Do you have other portions of that enforcement section that you have reservations about?
No, I do not.
Okay, so everyone can just give some thought. This is our discretionary decision as a task force about whether we want to make it clear that anyone who feels wronged can go directly to court. They don't have to exhaust the local administrative statute or process. So it's something we can decide next time. I think that's just going to be a straightforward decision. Shouldn't take too long. But how about on the notification provision and this issue of really that has to do with personal liability for city employees or agents? Is there someone who would like, who is willing to continue working on that and kind of take the lead on that discussion next time? I think 1 or 2 people would be great.
I guess I can take it. I've been working on this parts of this provision as it relates to notification for a while. So, but I would like some assistance.
Okay. Well, I know Barry's been working with you on this as well. And Barry, is this something that you also could assist with?
Sure, I'll be glad to help.
Okay. All right, I think that's helpful. Then, all right, and I see people are saying they don't see the packet on the website. I will ask Beth to make sure tomorrow morning, first thing, that that the packet gets onto the website. And so you can all have it tomorrow.
I apologize about all this funny stuff with the internet tonight. I don't know what's going on over at my house.
Sue, I'm having the same trouble. I'm on the telephone now.
Okay. Ooh.
So Councilor Hill, can we just talk schedule, do some backwards time planning, because it's Thursday, it'll be October 1st. Right now, I've tentatively have you scheduled for presenting your report and recommendations to the council at their meeting on October 21st. There are only 6 council meetings between now and the end of the year. You're not going to meet the first meeting in October, so you got the second meeting, and then we're in budget process. So what
No, I think we're absolutely going to be ready for that next meeting, for the meeting that you have us scheduled for. When do we have to have our materials to you to include into the city council agenda for that meeting, Sean? Is it 1 week prior?
Yeah, the Wednesday before.
Yep.
And you would my plan would be you're just going to present it to them. There wouldn't be significant discussion on that night. There'd be a public hearing scheduled. That would I would suggest probably end up being an off night because it's, I'm sure there'll be a lot of discussion about that. I'm not sure when that date will be because we have a bunch of public budget hearings that we'll be working on starting the first week of November. It's going to be a very tight season. And of course, we've got the deadline at the end of the year. So if you think you can meet that date, that's good. If not, that presents some problems as we get further into the budget process.
No, I'm absolutely committed to meeting that date. I think that, we have to conclude this process, and we've narrowed down the areas of divergence, and I think that I feel that we will be able to do this. And so what this means is that we need to meet next week for sure, so that we can resolve these areas of difference, or decide that there is no resolution and present two positions. This is something that we had identified at the beginning, that there might not be consensus in every area. And so maybe in the end, there will be consensus on the majority, but maybe there will be certain provisions where there are two positions presented or something like that. And so I think, if we simply cannot have a meeting of the minds, then that's okay. That's ultimately, this has to be resolved by the city council. And that's how this process works. So we were given a task, we were given a deadline, and I'm okay with going a little bit over the deadline. But I think the important thing is that, this gets implemented on January 1st, and we need to get our recommendations to the city council in a timely manner so that they can do their work, and the people will have a chance to weigh in at that level as well. So I think we've all agreed to meet next week. We have people who have taken on the two major areas of divergence. Are there any other areas? And then Bernie has also raised this other issue of the, how do you describe it again? But like how the police use a database, data collection. Is that, I don't know, I guess, Casey, is that something that maybe you could look into for next week?
Yes. Well, I was not part of the original intent. I honestly do not think that the intent was to preclude the police from doing these kinds of checks, because if that were to be the case, I think it will put the whole residents of the city in jeopardy. I mean, if you would stop a vehicle and you cannot see if that vehicle is stolen or something else, so I don't think that was the intent at all.
All right, I see heads nodding, so I'm hoping, so Casey, you can take the lead on this. And if there's anyone who really feels that they need to share something with Casey over the coming week, then please go ahead and do that. But we'll look to Casey to lead the discussion on that next week.
So, Councilor Hill, I have one more thing I think it's important that I bring up. There's one more factor. There's another whole group of people that this ordinance will impact. In fact, it specifically targets them, and that's the city employees. And I've got a meeting with the union presidents coming up, and I'm waiting for a version to actually get to them. So when you produce this, there will be no time for us to get back to you as far as a number of concerns that are already coming up that you don't even know about yet, and you won't have time to react. So you would be surprised at a council meeting, the things that I might say and that they might say, and that's not the intent, but we don't have a version yet that we can really comment on because it's still very much in draft form. I just don't want you folks to be caught off guard, which you will be, I suspect, because you won't have time to take that input and review that. And there are, again, a number of concerns.
Well, Sean, these are public meetings, and the public has been invited to participate in every meeting. And the public includes our city employees. And so I would hope that if there were city employees, including the city manager, who had concerns, that they would have been raising them along the way. We don't need to wait for a final draft to be listening to public testimony. That's why we've been conducting our work in public And so I really would hope that we would hear those concerns and not be surprised at the council table. I don't think the council is going to appreciate having to resolve those kinds of differences when the task force has been meeting. At least we have had almost a dozen, if not more, meetings in public session. So I would strongly encourage that we hear from members of any stakeholder groups who are concerned about the implications of this for their work or anything else before we vote on this as a task force, and certainly before it gets to the council table.
So just a couple of comments on that. At the beginning of this process, you talked about that we'll be seeking input from city staff and administration. You have asked questions of the police chief, and I have brought up a couple of things that are specific to questions that have been asked of me. And you've taken public comment every night at about 7:45. You've asked the task force members what they think, but you have not specifically asked what concerns the city administration has in regards to any of these provisions at all. You said you were going to do that. You have not done that. We are not the general public. We are the focus of this ordinance. And like I say, that has not occurred. And not only that, we don't have a finalized version to make comments on. I want to take whatever you've got here, and I'm not sure which one is which, but I want to get that to the union presidents. I'm going to be discussing that with them next week. But with version 6, provision number 6 is still unclear to me as to what you're doing with that. Is that the version you're going to put forward or not? There's supposed to be some comments made by Kira Kelly that were not added. They're not in here. I don't remember what they are specifically, so I don't have anything to get to them with a final document to say this is what they're talking about doing. So I just want to make that very clear, because I've been listening to language very closely in the recordings very closely. So I'm just making you aware of that now. And I wanted to avoid this situation where you can say, you never brought this up to us. This is a complete surprise. That's why I'm telling you.
Okay.
And the meeting for next week, Karen, how will we determine, or has that been determined when it is?
No, that has not been determined. It sounds like legal counsel is not available Monday through Wednesday. So I think we are looking at Thursday.
Although I do think that we've really had great input from Attorney Wall, but it might be that we need to do some just clarifying ourselves.
Okay. Well, then I think what we did here is that it looked to me that everyone was available to meet on Tuesday from 5 to 6:30. And so why don't we go ahead and schedule the meeting for Tuesday, 5 to 6:30. And I would like to make it explicitly and abundantly clear that I am inviting all members of our staff for the City of Lebanon to share their input with us prior to that meeting.
Prior to the meeting.
At the meeting, prior to the meeting.
Prior to the meeting.
I thought that the city manager was being our conduit and bringing us those concerns, but I hear now that that they were waiting for a direct invitation, and so I am directly inviting them.
Hope you've got time.
We do.
Good.
We do have time. That's why we've been doing our meetings in public and inviting the public to participate. So we have time. We have all the time that we need. Okay. Is there anyone else who has any comments? All right. Why don't we go ahead and have a motion to adjourn?
Barry Schuster, so moved.
Barry Schuster makes a motion to adjourn. Is there a second?
Sue Prentice.
Sue Prentice seconds. And let's go ahead and have the roll call vote. Kathy Beckett.
Aye.
Aaron Leo Hill says aye. Casey Montas.
Aye.
Hugh Prentice,
Aye.
Diane Root,
Aye.
Barry Schuster,
Aye.
Devin Wilkie.
Aye.
All right, this meeting is adjourned. Thank you, everyone.
Thank you all.
Thank you.